Well, first of all, as for the grounds for review, it's a very narrow corridor. And so they will first ask you what's the error of law. So definitely you need to demonstrate some error of law that, that occasion miscarriage of justice. As for miscarriage of justice, we all are the victims. The whole country is the victim if there's an error of law. But looking at it, I have already written that I think the Supreme Court didn't take into consideration some other words in Article 102, which has to do with the exception clauses, or with what I call the saving clauses. Article 102 is the only provision that mentions the idea of the presiding officer in Parliament not being part of a quorum. That's where it is mentioned. But we are asked to limit it to that provision. And I'm saying that there are some other provisions in Article 104(2) that import that limitation into 104. Because you see, if you look at that provision, 104(2) especially, which is talking about the members of Parliament voting, I think majority of members of Parliament voting, determining a matter by vote, you will see that it started with the words except as otherwise provided in this Constitution. And you see, and the except as otherwise is an exception for the quorum, is an exception for the number of members, is an exception for who will be a member of the quorum. That is being provided for in Article 104. For me, I have made that argument so clearly. I tried my best to make it so clearly that they didn't take into consideration those saving clauses. And you can see that in other provisions where there are saving clauses in the judgment, they took very serious consideration of them and they arrived at a conclusion. For me, I don't think the context of the Constitution, as they said, has warranted a departure from the provision that is linking speaker to a presiding officer. Because you see, a deputy speaker or anybody presiding is acting in the stead of a speaker. And there's a provision of the Constitution that says that anytime we mention speaker in the Constitution, we are referring to the person also presiding. But you see, the Supreme Court has come to the conclusion that no, that provision doesn't apply because in it, there is the word except or unless the context otherwise requires. And they went through the whole provisions of Article 95, 96, 97, and came to the conclusion, Chapter 10, and came to the conclusion that no, that context does not, requires that they don't call or they don't refer to the deputy speaker who is acting as the speaker, which means that every limitation, privilege, or right that applies to the speaker will not apply to the deputy speaker when he's presiding. I think I disagreed with that because I think that the context rather reveals otherwise, contrary, because you see, it is the principle of objectivity and impartiality that the context revealed that the framers of the Constitution wants to project. If you look at it well, because you see, when the speaker becomes a speaker, he ceases to be a member of Parliament. Now, if you look at, if we leave the speaker alone and go to the deputy speaker, you will find that if a minister or a deputy minister becomes a deputy speaker, under Article 81, he ceases to be a minister, which means that the Constitution doesn't want the deputy speaker, just like the speaker, to be a member of the executive. So you can see, so why would the Constitution prevent the deputy speaker from being a minister or deputy minister? It is because it wants to be, the Constitution wants him to be impartial because he would be presiding. And you see, to say that because there's an express provision relating to the speaker, excluding him from being, from voting or from having original or casting vote, but no express limitation on the deputy speaker, I think that also is erroneous.
All right. Now, if you can deal with this last one briefly for us, then we'll continue. You also impeach You also, like others, impeached the Supreme Court, as it were, invoking its jurisdiction to strike down Order 109 of the Standing Orders of Parliament as being null, void, and of no effect. How so?
Yes. You see, first of all, I expressed concerns about the jurisdiction of the Supreme Court not properly being invoked in this matter. Because, you see, we have looked at several cases and we have realized that even where the original jurisdiction is invoked in respect of interpreting some provision of the Constitution, if the provision of a Constitution comes up for interpretation which is not stated in the original rate, they decline interpretation of that particular, and I have cited several cases. But in this case, you can see that Justice Abdullahi never brought in any provision of law saying that it is inconsistent with any provision of the Constitution before the Supreme Court. Secondly, you could see that the interpretation of